Gotcha. All right, everybody, find a seat. We are going to continue. We are going to continue the fun, whether you like it or not. All right, before we get started, I have two things to announce. One, apparently we've fixed the video equipment, so the overflow room should be good to go if you want to go back up there, but why would you, you know? The other thing is enough random lost items have been found that there is now a makeshift lost and found out front here, so. And I haven't checked to see if there's anything good yet, but, you know. But don't forget to look. All right, our next panel is one of three panels where we asked the panelists to think in terms of a vision of the way things should be or the way you want them to be, and to think in terms of steps and processes to get us there. So a very solutions-oriented mindset is the goal here. The three talks in this panel, to various degrees, all speak to the subject of governance. What I call governance, that's for a lot of people that's the G word I'm not supposed to say, but you heard it and you said it. But there's so much of the conversation that's happened to this point has been about the G word, I think, in terms of talking about structures and processes and ways to improve inclusion and joint learning and joint decision making. So I think this by pure random chance falls in the right spot of the agenda. All right, we're going to start with John Berggren, who's known in some circles as handsome John Berggren. Admittedly, not a lot of circles, but come on, we can change that as a group if we just decide to.
Remember, he's speaking.
Oh, I know. Oh, he'll have his turn for rebuttal. All introductions, you guys should reserve time for rebuttal. He's the regional policy manager with Western Resource Advocates. So he made the 45-second walk across the street to be here today. Thank you, John. We'll then move on to Jason Robison, who you know by now, just from his stepping in to help with the questions. That wasn't the original plan, but I appreciate Jason helping out there. Jason's a law professor and prolific researcher at the University of Wyoming. And then we're going to Eric Kuhn, who many of you know and many of you got to know when he was general manager of the Colorado River District. Since leaving that position, he has become a very prolific author, I think in part because now he's free to say whatever he wants to say. And he says really smart things. So you know, my theory about conference planning is if you just put smart people behind a microphone, it'll go at least pretty well. And so Eric always has good things to say. So again, we're going to have those three talks in that order, unless you guys object, and then we will do the Q&A again, which I guess Celine will take the lead on this time. So John, handsome John.
How do we get the slides up? There we go. Thank you, Doug. Thanks. So Doug and I know each other for a long time. I was his grad student for many, many years. So I learned a lot from him. I also learned some things that I could also share about Doug, but I will not in this forum over that time. But so I was asked to give a talk about some of the research I did while working with Doug and some of the reading and writing I've done since on process in the Colorado River. I did want to acknowledge a lot of this thinking was a collaboration with Matt McKinney, who, as Doug mentioned yesterday, is unfortunately not with us at the conference, but he was really instrumental in helping put this together. And he asked me to put together a title with the most buzzwords as possible, and I think I achieved that. And I apologize how vague that title is, but hopefully this presentation will give a little clarity but really focusing on this idea of process, and I'll get to a little bit more of what that means. Just briefly, so as Doug mentioned, I work for Western Resource Advocates. We're a conservation nonprofit working on the Intermountain West on a variety of clean energy, water, and lands issues. And I was told, I got a text from our development director that our clean energy team, which fights climate change mitigation or fights greenhouse gas emissions in the Intermountain West, record-breaking donations after Peck's talk this morning. So thank you, Peck, and thank you to all your generous donations. I thought I was going to have to do a bit more context to set up this talk and why process matters, but yesterday and this morning really did the work for me. And part of the reason that we wanted to focus on process for this talk is, as we all know, there are immense challenges happening in the basin, both with post-2026 guidelines and all the parallel processes that we've been hearing about. And process is important because to meet those challenges, to help overcome those challenges, we need a process that fosters legitimacy. And I think unless we have a way to deal with the challenges, with the cuts, with all the pain that we're going to experience going forward, without a good process, it's not going to be sustainable. And so I wanted to start with, again, I thought I was going to have to set this up a lot more, but process matters. And I think we've all heard why that is the case today, or yesterday and today. And as I said, legitimacy is really key for overcoming the many challenges that we face. And hopefully what you take away is that I don't know what I'm talking about. I'm going to ask a lot of questions, and I think we should have the conversation about those questions. And these questions, I think, help ensure that our decisions reflect a broad range of viewpoints and values in the decision-making process. So because this is a process topic and presentation, of course, I have to start with Article 1 of the 1922 Compact. The major purposes of this compact are to provide for the equitable division and apportionment of the use of the waters of the Colorado River system. What we've heard a lot for many years, and especially yesterday and this morning, is there's disagreement about what this actually means to have an equitable division. And so I spent some time thinking or doing some research on what other folks have said about what equitable division actually means and how to define it. And I've come across several good quotes, I think, from some resources that help begin understanding what equitable division or equitable process might be. And I apologize for the long quote, but I will read it. It does not help much to say what is needed is an equitable division of water between the states. What is needed is a standard which may be applied in order to determine what is an equitable division. It is submitted that some sort of basin-wide entity, and I'll talk more about this later, by hearing a number of cases from time to time and by dealing with subject matter relating to the problems which center around the use of the water in the Colorado River, will develop the technique essential to efficient administration. I was curious if anyone had any thoughts of when that might have been written.
Rule Olson.
Colorado River nerd Jason Robison got it. Rule Olson in 1926, which was probably the first robust academic analysis into the Colorado River Compact, identify this right away. We can't just say we need an equitable apportionment. We need to figure out what a process is around that. Another quote I wanted to highlight: the awkwardness and intractability of most of the Colorado River's problems reflect the absence of a venue to deal comprehensively with Colorado River Basin issues. Again, any thoughts on when that was written or who that was written by?
Well, we're at CU Law School, right?
Uh-huh. It was the namesake of the center back in 1997, David Getches. And I think he's actually, in this paper in 1997, he's actually referring to an article he wrote in 1989, I believe. So he was thinking about this. He's one of the forefront thinking about process. And for one of my favorite quotes, for a document at the foundation of Colorado governance, the compact has remarkably little to say about the subject. Any guesses when that was written or who said that?
Yesterday.
Could have been yesterday. That was John Fleck just a couple years ago. So again, I thought I was going to have to set up more of why we want to focus on process, but I don't think I really need to. Everyone knows to be successful, we need both substance, and this was a lot of conversation yesterday. This is a lot of conversation around post-2026 guidelines. We need the solutions, the policies, the tools, the actual substance to help us manage the reservoir operations, the allocations to help us manage the system more sustainably. But what I'm talking about today is we also need an effective process to engage sovereigns, and stakeholders at the right level, at the right times, for the right reasons. And so the remainder of this talk is really going to be focused on the second half of the process. I did want to talk about a little bit of where we've been, but again, we've talked a lot about this in the last couple of days. And of course, starting back in 1922, tribes' environmental considerations were not included in that decision-making process. And as Daryl noted just in the panel before, there's been a great improvement in the trend in terms of how tribes are included and how tribes are involved in the decision-making process. This, of course, is from the MOU just about a month ago that Daryl and that others have referenced. And as Daryl highlighted, this isn't the end-all be-all, but this is an improvement. This is institutionalizing. This is a MOU between the Upper Basin states and the Upper Basin tribes about process. And so I think it's important to note that we have made this improvement over time. And similarly with the environment, again, historically excluded from the decision-making process, leading to pretty negative environmental outcomes. Today, we do have a whole bunch of environmental programs, laws, policies that have been grafted onto the law of the river and do some good work. And notably, the Grand Canyon Protection Act was a pretty significant inflection point in terms of considering environmental values in the law and in the law of the river. But still, to this day, a lot of those environmental laws are kind of subservient to the allocative laws. And I think Karen Kwan had mentioned this yesterday. There's opportunities to actually integrate those environmental considerations into the broader law of the river. And so we can make some improvements, and there have been improvements, both in terms of endangered species management, things like the Colorado River Delta habitat restoration. There have been improvements, but we still have a ways to go. So I thought I was going to have to go through a lot of the recent efforts, but again, my thunder's been stolen that all this has been talked about in the last couple of days. Just in really recent times, in terms of federal efforts, there was the Tribal Information Exchange last year, the Fed Tribe States Group, the 38 Sovereigns, as it's been referred to, the web-based tool for post-2026 operations from Reclamation. That's a significant effort. And then Commissioner Tootin talked yesterday about the 30 government-to-government consultations that the federal government has engaged in. So a lot of good things happening at the federal level. At the state level, this has again been mentioned, the ARC, the Arizona Consultation Committee. Here in Colorado, the sovereign-to-sovereign dialogue with the state and the tribes. And then tribal leaders actually being appointed to decision-making boards in several of the basin states. So again, good improvements in the formal process. And I just want to highlight, there's also been improvements in the informal process. I took this from Twitter, so this is public, from the Colorado River Authority, but this was Amy Haas going out fly fishing with a couple of folks from Trout Unlimited, an example of the informal process that's happening where decision makers and representatives from Trout Unlimited are able to have a conversation on the river while fishing. So wanted to highlight some of the informal improvements as well. Here in the Upper Basin, again, this has been mentioned, but the MOU that was just signed last month, the DROA, Drought Response Operation Agreement, and a lot of the significant stakeholder and sovereign outreach around that. The Upper Basin Dialogue Group that Daryl had mentioned in the last panel between the tribes and NGOs. And another recent effort I want to note was the significant media coverage that's happened around this improvement in process. I know you can't see that, but this is from the Water and Tribes Initiative website where they've captured all the recent media on what's been happening with the tribes in Colorado River Basin. And it's just to say that the process is improving and we're getting additional coverage in the media about that improvement in the process. Same thing, we're seeing stories written about what it means to actually consider environmental values in Colorado River management. So that's a little bit of where we've been, recent efforts. And the task of our panel in this talk is moving from vision to action. And so there's three things I think are important when thinking about action. One, build upon successes to date. These recent efforts have enhanced transparency, they've increased participation and trust, fostered lots of information exchanges, and advanced a common understanding of these complex issues and diverse interests. So what we've done is good, but as we've heard, it's nowhere near where we need to be, and we need to continue, but they provide good examples of how we can build upon those processes. probably need to institutionalize some of these efforts. So the tribe states feds group or the 38 sovereigns, maybe that can be fully institutionalized in something that is alive beyond the post-2026 guidelines. Something like the MOU and the Upper Basin institutionalizing existing efforts to date. And then what I want to spend the rest of the talk on was exploring some sort of basin-wide forum. And again, I'm not going to have any answers about this, but I will pose a lot of questions about it. And this is get back to that David Getches quote about maybe the problem we're having is we don't have some sort of basin-wide thing to deal with some of the challenge we're facing. And so what this basin-wide something could look like, is it a forum? Is it a venue? Is it a place to exchange information, build relationships, and develop collaborative solutions? Maybe it's a time, as I mentioned, David Getches talked about some sort of river basin commission. This is not something that we came up with. This is international best practices. So I think about 80 to 90% of international transboundary river basins have some sort of river basin commission that helps looking at the entire basin, includes multiple perspectives, stakeholders, sovereigns, and multiple values. And so it could be an opportunity, that could be an area where the basin is interested in going. It could also be something much less formal, and just a place for conversation, or just a place to listen. I think a lot of what we've heard is the need for this. And again, if it's not a formal venue and not a formal river basin commission, maybe it's an informal place to hear each other out. And not just the sovereigns, not just the stakeholders, but everyone. In a place where we can really get to know and hear each other. I think it was Commissioner Salmon yesterday said, if you're only meeting semi-regularly, how are you going to know how many kids your counterpart has, how many grandkids they have, how are they doing? And I think developing some sort of basin-wide entity might be a place where we can all do that together. So again, I don't have a specific proposal. I don't have a specific answer here. All I think is this is an opportunity and this is a time where we can consider some sort of basin-wide entity. Is it just the sovereigns? Is it something just like the UCRC model basin-wide? Is it like the 38 sovereigns group? Is that the basin-wide entity that we're interested in institutionalizing? Is it sovereigns and some set of stakeholders? Obviously, we can't have all stakeholders involved, but some representative of environmental NGOs, of recreation, of other stakeholders, municipalities, ag, all that. Could this entity include different perspectives in that regard? Are there other subsets of what I'm talking about? So just to throw out some ideas, could we have some sort of scientific advisory panel that deals with or tries to translate the latest science that we're hearing about and what it means for Colorado River management? Is there kind of an independent legal committee? There's a lot of uncertainties and unknowns with the law of the river. I know Eric's going to get into this a little bit, but can we have some entity that looks at this from a basin-wide management and what are some of these unknown or ambiguities in the law of the river that we need to address? Some sort of public participation committee. Is this a way to get input from the broader public of the 35, 40 million people who rely on the Colorado River or the country as a whole? Can we have some venue for soliciting that input? And getting more granular, with Grand Canyon management, I think one thing we've learned is we know how to manage it. We just have to decide what to manage it for. And I think some sort of entity or working group to help us understand what we care about in the Grand Canyon, what we want to manage it for, might be helpful in terms of incorporating these environmental values into the decision-making process. So I'll hold off on that for a second, but one thing that I've heard in response to this idea, and I'm sure many folks in the room are thinking, is this just adds another layer of bureaucracy. We're already busy enough. I know the basin states, I've said publicly they're not super on board with this idea, but I think what I'm hopefully going to convey is this is a way to actually make your job a little bit easier. I think give you more legitimacy and help you come to the tough decisions that you have to. And this is a quote, and I'll read it. So this is from a book chapter that I wrote with Doug and John Fleck and Mariana River-Torres in Jason's book a couple years ago. But inclusivity does not threaten the special status of existing decision makers. Inclusivity puts those decision makers in a setting where they have more resources, information, and perceived legitimacy to bargain. The Colorado River Compact, after all, is a bargain, a negotiated agreement born from the realization that it was better to make a deal than do nothing, to litigate or to delegate important regional decisions to a distant national government. And so, again, I don't know the answer. I don't know if this basin-wide entity should be formal through congressional authorization and have decision-making authority, or should it be simply advisory? Should it be informal? Should it be grassroots? But I do think I know that if there's a limited number of people who are ultimately making decisions, the legitimacy is going to be, there's going to be less legitimacy, and it's going to be harder to get people on board with the challenges that we have to face with what we're facing in the future. I think there's universal agreement that the post-2026 guidelines are going to be a new way of managing the system. There's going to be different allocations, there's going to be different shortages, and if we want people on board with that new way of management, I think we need a process that helps them feel like it's a legitimate outcome. And people need to feel that their time and investment in this is worth it. And so that if they don't feel like their time in a lot of these processes are worthwhile, I highlighted a lot of the recent efforts, but if folks feel like their voices are still not being heard, that's going to be a challenge for legitimacy. And like I said, ultimately, what I think this is putting us on the path where is you as decision makers, this makes your job easier. And I want to highlight that I think this helps empower you to make the difficult decisions that you all have to make. So why think about a basin-wide forum or venue? I've alluded to this, but it helps build consensus to solve these intractable problems. One, I think, real prime benefit of this type of conversation, at least, is the data sharing and the trust building that comes with it. And we heard that a lot yesterday, that we need folks to understand, be on a common playing field when it comes to data, and have that trust built, and only then can you start making consensus decisions. And I think things like dealing with the math problem come when you have that level of trust, and I think this entity or this forum could help deal with that. What we heard a lot yesterday was the need for new, flexible, and innovative policies and programs. This type of conversation or venue could be a great place to learn about those, to hear about them, hear pros and cons about new flexible tools. And decision makers can learn from that and hear what other folks are thinking. We have a huge, diverse set of expertise working on this river, and I think this type of venue could really help elicit innovative, flexible ideas. I think this, and this goes back to what I was saying earlier, this could help avoid undesirable outcomes. I think we heard yesterday from the basin states that while litigation is something they're not going to take off the table completely, it's something that we all want to avoid. And I think if we're able to have these conversations basin-wide, we might be able to avoid some of those really undesired outcomes. And then I think importantly is this type of venue would really help us manage the system holistically. We've been talking a lot about post-2026 guidelines, but we've also been talking a lot about the parallel processes that are needed. And that's just in the short term. Long term, we're always going to have challenges that we to face on this basin. I think Peck really nailed that home, that things are always going to be a challenge, and if we have a way to continually have this conversation, we can be proactive about addressing those challenges holistically. And then the last reason I want to highlight is it's this concept that I learned about during my research in grad school when I was talking to some decision makers from Mexico about their experience with Colorado River negotiations. They referred to this term as catharsis, and I haven't really heard it elsewhere. But the idea of catharsis is that if you're negotiating over water, Colorado River, you really have to understand your counterpoints. You have to be empathetic. You have to know where they're coming from. You have to know their values, objectives, goals, politics. And only once you have that understanding, you can be effective in coming to an agreement. And I'm going to put up another long quote, but the first part of the quote is just talking about what catharsis is, and the second part of the quote is highlighting why it's important. And so catharsis means you need to understand the other position of your counterparts. You need to accept all the complaints of the other part. You need to understand what those complaints are based on in order to better establish bridges of communication with the other party. That's what it is. So, and then this was 6 or 7 years ago in regards to a policy they're working on. We could have agreed to this new policy. I'm pretty sure about that, but there was a change in people on both sides, and new people haven't had the time for the process of catharsis yet, understanding their counterpoints, understanding the points of view of the other parties. And so what I think whatever I've been talking about might be the venue or the space for everyone to have the process of catharsis with everyone. And then finally, and this has been alluded to as well the last 2 days, is values are going to change on this basin. Certainly we have some baseline values about what we care about, but most notably, we always talk about what we cared about in 1922 might not be what we care about today. And we've seen this evolution in values over the last 100 or so years. And this change is, I think, inevitable going forward. And so whether it's water supply, we've seen the change in tribal inclusion, an improvement in environmental considerations, things looking at the Delta, Grand Canyon, other Salton Sea, other aspects of the river. And going forward, our values are going to continue to change in what we care about, and the science is going to continue to change. And do we have a different opinion about Lake Powell and how Lake Powell should be managed? Do we care more? Do we tend to care more about what's emerging out of Glen Canyon compared to a full Lake Powell? And so I'm not advocating for any of that. All I'm saying is I think our values are going to change, and I think we should have a space to talk about those changing values. And I think why I think about this a lot is this is my 2.5-year-old daughter, and I like to include her in presentations, not only because I think she's the cutest kid in the world, but for future generations, for her generation, I want to make sure we have a process set up where her and her generation has a space to have their voices heard. And so I will leave her up and come back to my key takeaways of hopefully I've helped you understand the process matters. Legitimacy is key for these challenges, and we should be asking a lot of these questions to ensure that our decisions reflect a broad range of viewpoints. With that, I will.
Awesome, John, thank you.
Which mic? Did you leave this off? No, turn it on. That one's.
All right, we will continue our catharsis.
And then you want to be right.
Jason, you are almost up.
All right. I think I'm going to try to just use the lapel mic. Is my audibility okay? Working? Good deal. Okay. Thanks so much for the invitation to speak. I think I mostly owe Daryl and Doug. Thanks for that. Appreciate it. And thanks in advance for audience members in person and virtual for putting up with me. The comments that I'm going to offer dovetail pretty closely with earlier content covered in the conference agenda, the Tribal Sovereigns panel yesterday, and definitely the morning panel of today. So there's connection there. Analogizing my presentation to a recipe, it draws on diverse ingredients. Part of it is going to be about American federalism. Part of it is going to be about equity or justice for Native peoples. And part of it is, of course, going to be about the management of America's Nile, the Colorado River. Specifically, nice. I'm going to start off by reviewing the presence of tribal sovereigns within the Colorado River Basin and then delving into American federalism. That is the unique trust relationship that exists between the United States and tribal nations as sovereigns. At that point, I'm going to turn to the Basin Tribe's water rights and spend a few minutes discussing the status of those water rights as assets subject to the trust relationship. Then, most importantly, I'm going to spend the rest of my time focusing on the trust relationship's implications for the future of Colorado River management. This last section captures what is my overarching thesis as one of your presenters, that the trust relationship should shape future Colorado River management. Although, as you'll see, I would be genuinely curious about what all of you think regarding exactly how that should look. So that's my roadmap. Turning to the initial material, Again, some of it overlaps with past presentations and remarks. For example, the tribal sovereign's presence within the Colorado River Basin. But the trust relationship content that I'm going to delve into, I'm hoping that you find that new and worthwhile. Here's the basin map again, which I've included in my slide deck, not so much for its depiction of the river system, but to reiterate what a remarkable space the Colorado River Basin is from the perspective of sovereign relations. The basin's co-sovereigns involve 2 nation states, the United States and Mexico, 7 US states, as you are aware, and alongside them, 30 tribal nations. A third layer of co-sovereigns, 30 basin tribes. I'll just say anecdotally, growing up in Salt Lake during the 1990s, I was taught in school about the federal government and the states as co-sovereigns, but not about the tribes. Put differently, federalism is something that I personally learned about, for example, in my high school US government class, in a binary or federal state way. And that's flawed and too limited. Just as there are 3 branches of our federal government, so too are there 3 types of co-sovereigns within our nation state. Moreover, just as a unique, sometimes contentious relationship exists between the federal government and the states, so too is the character of the co-sovereign relationship between the United States and tribes remarkably distinct. It's a trust relationship. It's one that's existed since the United States' founding as a country. This trust relationship has been referred to in some instances as a, quote, guardian-ward relationship, stemming partly from the United States' Supreme Court's initial opinion recognizing the relationship in 1831, Cherokee Nation versus Georgia. That label, however, to be clear, is ethnocentric and infused with racism. And a much better case for understanding the trust relationship is Worcester versus Georgia, handed down by the court the following year in 1832, where Chief Justice John Marshall rooted the trust relationship in treaty provisions containing promises of protection made to tribes by the United States. What Chief Justice Marshall saw in these promises of protection, viewing them through the lens of the law of nations, was the creation of a protectorate, which is fascinating to think about from the perspective of non-binary American federalism. Whereas the previous quote from former Assistant Solicitor Chambers focused on the trust relationship's origin in the treaties. This quote from former Interior Solicitor Leo Krulitz describes how post-1871 treaty substitutes creating Indian reservations also entailed implied promises of protection made by the United States to tribes, for example, in executive agreements or presidential orders. So, a general trust relationship exists between the United States and tribal nations, as acknowledged by the US Supreme Court, most notably, in my opinion, in Worcester versus Georgia. And this trust relationship is generally thought to originate from promises of protection made by the United States explicitly or implicitly in treaties or treaty substitutes. Building on this doctrine, as identified in this excerpt from Secretarial Order number 3335, issued by former Interior Secretary Sally Jewell, the trust relationship between the United States and tribal nations as co-sovereigns applies across the federal government horizontally as a whole. Former Secretary Jewell's quote notes this fact with respect to the legislative and executive branches, including, of course, the Department of the Interior within the former. This quote from one of my beloved former professors at the University of Oregon, Professor Mary Wood, echoes this important point about the trust relationship, quote, blanketing, if you will, the federal government, the entire federal government. Put differently, the trust relationship has important implications for all three of the federal sovereign's branches, legislative, executive, and judiciary, including, again, federal agencies such as the Bureau of Indian Affairs and the Bureau of Reclamation. So that's it for my initial remarks about basin tribes as co-sovereigns within American federalism and the unique character of the trust relationship shared by the federal and tribal co-sovereigns. Now I'm going to pivot to water, specifically to water rights held by basin tribes and how the trust relationship applies to those rights. You've heard it before already at the conference. Winters is the seminal U.S. Supreme Court in this space. Handed down in 1908, Winters applied the Indian canons of construction, which grow out of the trust relationship, to an 1888 agreement establishing the Fort Belknap Reservation in Montana. In a nutshell, the court held that where water is essential to fulfill the purposes for which an Indian reservation has been established, an Indian reserved right to use such water is implicitly created upon the reservation's establishment, despite no express text about tribal water rights appearing in the treaty or the treaty substitute. As a U.S. Supreme Court decision, the Winters Doctrine, of course, applies nationally. Roughly a half century after Winters, 55 years to be precise, in 1963, this epic decision in the Arizona versus California litigation was handed down. The U.S. Supreme Court, in this case, recognized and quantified the reserved rights of 5 basin tribes along the Colorado River main stem below, not above, but below Hoover Dam. This table from the Bureau does a nice job synthesizing the considerable diversions, check them, and senior priority dates associated with these reserved rights. Moving forward from the 1963 Arizona versus California decision, most basin tribes have chosen to enter into negotiated settlements to have their winners' rights recognized and quantified. The prevalence of this approach is attributable to many factors, but among them are the U.S. Supreme Court's decisions in Colorado River, 1976, and San Carlos, 1983, construing the McCarran Amendment as allowing state courts administering general stream adjudications to exercise jurisdiction over Indian reserve rights claims. All told, beginning with Ak Chin in 1978, the first tribal water rights settlement in U.S. history, basin tribes have entered into 17 settlements to date, with more presently in the works, as we've discussed vis-a-vis northeastern Arizona. So, in sum, although nearly a dozen basin tribes have not yet had their water rights addressed at this time, mind you, 116 years after Winters dropped, 5 basin tribes have had their water rights quantified in Arizona versus California, and 17 negotiated settlements quantify other basin tribes' water rights. These water rights are subject to the trust relationship. Put differently, the trust relationship applies to the water rights which are defined as, quote, Indian trust assets, ITAs as a shorthand. So this excerpt from the Bureau of Reclamation's ITA policy and NEPA implementing procedures offers a definition of ITAs. The trust piece of the definition at the bottom is worth highlighting. The United States, in its role as a trustee, holds title to trust assets for the benefit of tribes as beneficiaries of the trust. This text, in turn, clarifies tribal water rights are one type of ITA that's subject to the trust relationship, unequivocally. As the middle part of the excerpt explains, quote, the United States has a trust responsibility to protect and maintain ITAs such as water rights. In the context of NEPA processes, the excerpt describes how it's necessary to analyze different alternatives' impacts on ITAs, including actions that could interfere with the exercise of Indian reserve rights or degrade water quality where Indian reserved rights exist. The Bureau's ITA policy and NEPA implementing procedures apply nationally. across the United States. So I thought it would be well to also cover a Colorado River Basin specific document that dovetails. The final environmental impact statement, FEIS, for the 2007 interim guidelines is a particularly useful one in my view. This excerpt from the FEIS mirrors the excerpts highlighted above. I'll focus on just two aspects of it. First, it identifies the United States' trustee role and associated duty of protection with respect to basin tribes' water rights. Second, the excerpt drills down into the types of water rights considered ITAs and thus subject to the trust relationship. 1, Indian reserve rights contained in the Arizona versus California decree. 2, tribal water rights set forth in negotiated settlements. 3, notably, at least with respect to the Dene, unquantified water rights of the Navajo Nation, which the excerpt describes are also, quote, considered an ITA. So, to summarize the preceding material, rooted in winters, basin tribes possess quantified water rights under the Arizona versus California decree and 17 negotiated settlements, as well as some water rights that are unquantified at this point in time. And these water rights constitute Indian trust assets that are subject to the trust relationship. So for the remainder of my time, I'd like to ask all of you, all audience members, in person and virtually, to consider what this state of affairs, this trust relationship, and its application to tribal water rights should mean going forward along the Colorado River. I want to start off this line of thought by reiterating something mentioned earlier. The trust relationship is something shared by the United States and tribes that applies to all three branches of the federal government. That said, I'm not going to delve into the U.S. Supreme Court here. The court has recognized the general trust relationship's existence for nearly 2 centuries. Again, in my view, the 1832 case of Worcester versus Georgia is especially foundational. Further, over the past 44 years, the court has been developing an analytical framework for breach of trust actions brought by tribes against the federal sovereign, against the United States, beginning with the case of Mitchell 1 in 1980. Respectfully, I have criticisms of the court's breach of trust analysis, but for present purposes, for purposes of this presentation, neither that analysis nor the court are what I'd like to draw our collective attention to. Instead, I'd like to focus on Congress and the executive branch. Put differently, I'd like to focus on the policy sphere versus litigation. And here's the specific discussion question that, if I may, I'd like to ask all of you to consider. How would you like to see Congress and the executive branch fulfill the trust relationship in future Colorado River management with respect to the post-2026 management rules and more broadly? My intent in posing this question, and this is really important to me, is not to be up here as an academic talking head that is capable of providing definitive answers to the same question I've posed. I genuinely would like to hear what you all think, what your respective answers are to this question during Q&A. And for the rest of my time, I'm just going to share a few bits of input based on things that I've gleaned over the past several years as somebody, for good or ill, who's thought a lot about this question. But I really care about what you think more than what I think. This executive order issued by President Biden last December 2023 definitely comes to mind for me when thinking about the trust relationship's role, in shaping future Colorado River management. We as a nation state are more than a half a century into the self-determination era of federal Indian policy. That means something. Key principles of this era include respecting tribes as co-sovereigns, protecting tribal sovereignty, and respecting and supporting tribes' rights to self-determination. However, the trust relationship is prospectively approached along the Colorado River in the coming years. The executive branch and Congress would be out of sorts if that approach did not honor these key principles of our current policy era. Against that big picture backdrop, here's another thing I've gleaned for what it's worth, stemming from a joint tribal letter submitted to Secretary Howland by 20 basin tribes in November of 2021. The trust relationship requires the United States to ensure structural inclusion, you've heard it, for tribal co-sovereigns in policymaking involving Colorado River management. This viewpoint connects directly with the previous presentation and the presentation yesterday by the tribal sovereigns, our tribal representatives. Echoing this viewpoint is the Jicarilla Apaches scoping letter to the Bureau of Reclamation on post-2026 management rules. Powerful message in this letter. Consistent with the trust relationship, quote, the nation proposes that Interior create a formal and permanent structure for tribal inclusion in Colorado River decision-making. Granted, the letter reflected the federal, states, tribes groups formation around this time, just prior, as an aspect, a parallel aspect of the post-2026 process. But what the letter calls for, again, quote, a formal and permanent structure for tribal inclusion goes beyond. The letter is also notable, I love it, for how it connects tribal inclusion in decision-making to protection of ITAs, protection of Indian trust assets. Quote, to adequately protect the Jicarilla Apache Nation's interests, we must be part of discussions as they occur, ... It is the federal government's obligation to create an environment in which this occurs. All right, another recurring theme that I've noticed when thinking about the trust relationship's future fulfillment along the Colorado River concerns tribal water rights, go figure. Their protection, their development, their eligibility in regards to future conservation programs, forbearance agreements, and off-reservation leasing. All of these topics are broached in this March 2024 letter submitted by Basin Tribes to Commissioner Tootin. This excerpt focuses on how the trust relationship requires the federal government to fully analyze in the NEPA process for post-2026 operations, quote, potential adverse impacts to tribal water rights. This excerpt elaborates by focusing on the Indian reserve rights set forth in the Arizona versus California decree, there along the main stem. The trust relationship calls for rejecting any operational alternative, imposing involuntary or uncompensated out of priority cuts involving these water rights. And the trust relationship also calls for ensuring that the tribes benefit from alternative water supplies if the post-2026 operations disrupt their water rights. A similar view is expressed in this excerpt addressing Basin Tribes with CAP, Central Arizona Project rights under negotiated settlements. The trust relationship requires the federal government to find, quote, alternative water supplies that are equivalent in value to the water rights lost due to cuts under the post-2026 operating regime. And this excerpt, which is my last from the March 2024 letter, dovetails by connecting the trust relationship to funding. Specifically, the federal government's trust responsibility to seek and secure adequate funding to ensure federal protection of Basin Tribes' water rights. All right, along parallel lines, outside the bounds of the March 2024 letter, the path-breaking universal access effort in recent years has put out some material, including this 2021 report that's been very thought-provoking to me personally when thinking about the future fulfillment of the trust relationship in Colorado River management. This excerpt is strong and straightforward. Quote, access to clean drinking water and sanitation is a human right. Providing this access is central to the federal government's treaty and trust responsibilities to tribes. Another worthwhile report that I've come across is the Water and Tribes Initiative's 2023 report on enhancing Basin Tribes' water management capacity. This summary table identifies a host of capacity-related policy priorities that implicate the trust relationship that Congress and the executive branch could, and in my view, should help with. Now, while the capacity building report covers a lot of ground. One important aspect of it is captured in this excerpt, and I had to bring it in. It expresses tribal frustration with, quote, having to educate federal officials about the basics of tribal sovereignty and the trust relationship. This capacity building need is focused on the United States. Granted, the need for education and training regarding the trust relationship for federal employees who are engaged in water management. The excerpt doesn't focus on the basin tribes, but it nonetheless reflects something important that tribal leaders and members felt comfortable enough to share, and I wanted to do the same. Okay, so to wrap up, the preceding 10 slides convey a sense of some things that I, as one individual, have gleaned over the past few years when thinking about the discussion question. Again, how would you like to see Congress and the executive branch fulfill the trust relationship along the Colorado River in future management? I genuinely enjoy hearing anyone's thoughts on that question during Q&A or elsewhere. But for now, I want to pan out with this excerpt from former Assistant Secretary for Indian Affairs, not David, but Kevin Gover. My takeaways from the excerpt are threefold. One, the trust relationship is a defining aspect of American federalism, even though it's commonly overlooked, and federalism's instead generally thought of in federal-state terms. Two, in the self-determination era, the trust relationship should be fulfilled with unwavering respect and support for tribal sovereignty and self-determination. Three, the trust relationship should involve partnership between the federal and tribal co-sovereigns, not federal paternalism. If you're interested, please take a look at this law review article, Relational River, for a more in-depth discussion of everything I've gone into. Again, thanks a lot for inviting me and for all of you for hearing me out.
Thank you, Jason.
Well, thank you. I'll try and use, instead of my little mic, I'll try and use this one. But first, I wanted to make a little plug and discuss the proposal that's been labeled the Schmidt-Fleck-Kuhn proposal, and talk a little bit about that, and then I'll go into my assigned topic, which is to have a little conversation with you about landmines and tripwires. But I'm really glad that we were on Carly's slide yesterday. I think that's a big step. It means I guess we're on the scout team. But what we're basically suggesting is that, what we did in 2007 is we set in place a set of guidelines that dictated what the annual release from Glen Canyon would be based on certain conditions. And those conditions were storage in Meade and storage in Powell. Now, once that was set, it was, quote, fixed. By fixed, I don't mean it had to be the same number because it could have been a range. And what we're suggesting is that in the next 20, 30, 40 years, there's going to be surprises out there. We're going to learn a lot about the ecosystem, a lot more about the ecosystem in the Grand Canyon. There's going to be value changes. Some folks like the idea of, Dark Canyon resurfacing, the Return to Rapids project. So locking in another, quote, fixed release pattern for water supply purposes for Glen Canyon to us doesn't make a lot of sense. But at the same time, we acknowledge that it's the likely outcome of a 7-state solution, just like it was back in 2006, 2005, and 2006. Now, we may have been foolish in making the assumption that the upper division and lower division states will come together and propose one. I think that's still on the table. But another one is that reclamation could pick and choose from each proposal and perhaps throw in the environmental proposal as well. So we're going to end up with a classic approach. If there are certain conditions, then the annual release for water supply purposes is Y, okay? And then those variables will change, but that pattern is what we've used at least for the last 20 years. Now, what we're suggesting is very simple. If that annual release for non-water, for water supply purposes creates a problem for non-water supply issues, Carly mentioned one yesterday, structural infrastructure at the dam safety. Another one is what's actually happening in the Grand Canyon. That you go ahead and pretend you're going to follow the 7-state proposal if there is one, but you create two simple accounts. One is an upper basin account in Lake Mead. You use that if you actually deliver more water than what the prescribed release would be, or a lower basin account in Glen Canyon. You use that if you release less water than what the prescribed release would be. And it's basically an approach. Now, in doing this, we realize we're providing the skeleton. I like to say it's like a bicycle with one speed and pedal back brakes. We understand by the time that all of the interests get involved in how do you actually implement such an accounting proposal, it might look more like a Mars rover. But at the same time, we just think we're ready for that. Just like in 2007, we were ready to break away from the LROC model that was 823 or a big release based on equalization or control, fill without spill. This is the next step. It's provide some flexibility to deal with actual conditions in the canyon or actual conditions at the reservoirs, actual conditions with the dam infrastructure, even power generation. So it's anything that's not specific to water supply, and put together an accounting system with some constraints, understand those have to be negotiated, that would provide to keep an agreement that might come out of the 7-state discussions whole. So that's kind of it. We can back this up now. One thing I wanted to mention is a good example of that is this question of sediment management in the canyon. It looks like, monsoons are hard to predict. Really, you can't predict monsoons. You're going to know you have a good or bad monsoon or average monsoon when the monsoon season ends, and not before. So that we know that if you have bad sediment, if you don't have a good monsoon, you don't get a little bit of sediment from the Paria and the other tributaries, and you release too much water, you're causing problems. So this is from the USGS, and essentially this basically, it'll, as Jack Schmidt says, as we get more data, this graph might look very different, but it's one indication of how you might use this flexibility to actually adapt to what we're actually seeing, so they have another tool to manage sediment conditions in the canyon, but at the same time keeping the states whole. So with that, I think I will go on to my assigned topic, and I'll try and do that quickly so we have some time for questions. And essentially what I wanted to talk about is what we heard yesterday. We heard all 6 states say that, litigation isn't off the table, and it's not our decision to take it off the table. The people we work for will decide that. And a little bit about, that's a little scary to me, but it's also realistic. And Jim Lockhead's here today, and he's done some incredible things for this basin in the past. But one of the things he coined, at least I believe it was his term, was the term compact tripwire. And the first compact tripwire was an 82 million acre foot 10-year flow at Lee Ferry. Where do we come up with 82 million acre feet? Well, it's 75 over 10 under Article 3D. And then it's the lower basin or the lower division states interpretation that they've reiterated in several comments just recently on the system-wide or on the EIS, that the upper division states have, there's no surplus in the system, so they owe 750,000 approximately every year. So times 10, that's 7.5, and 75 plus 7.5 is 82.5 million. Now that's going to be adjusted a little bit because in some of these years under the minutes, Mexico is getting a little less. So maybe it's 82.3 or 82.4. But nonetheless, we're headed for this tripwire, and let me explain why. The 10-year moving average right now, I think if you look at the UCRC's latest report, is like 80, I'll round it off to 86 million, 86.1 million acre feet. This year, it's not going to change because the way the 10-year process works out at the end of this year, 2014 will drop out and we'll add in 2024. That gives us 10 years. What was 2014? It was a 748 release. This year is a 748 release. So the number, it might change a little bit because the leakage around the dam and maybe the Paria River will be different, but no big change. Well, what happens next year? Well, recall from 2015 through 2019, we had 5 straight years of a 9 million acre foot release. And we know that in 2025, we're going to have a 748. So the next time we do this, we're going to drop out a 9 and we're going to put into the 10-year calculation a 7.5. So we're going to, that 86 goes to like 84.5. If we do that again in 2026, it'll be down to 83. Right now, I think the 24-month study a few months ago was showing a 748 release in 2026. Now it may be more than that, but it's right at the cusp. If we have a classic La Nina year following these wet years, we could easily see, especially with a dry fall, we could easily see a 748 year next year. So we're now at 83. And we still have 3 years left of those high releases to deal with in 27, 28, and 29. So the chances of then releasing 26.5 million acre feet, which is what it would be needed over those next 3 years, in my view, is pretty small. And the River District in its phase 4 study and others have kind of confirmed this. So what all this means is that some point here in the future, the lower division states and the UCRC are going to be at a crossroads. They're going to have to say, what do we do if we drop below 82.5? And that's why Jim called it a tripwire, because at some point, someone's got to make a decision about the compact, and are they going to enforce it? That's why I think the lower division states are saying, litigation can't be off the table. That's why Tom Bushofsky can't really go to his legislature with the compact as an issue and say, well, yeah, we just kind of acceded to the upper division states issue, position on this. We gave them that. I don't think that's going to happen. So we end up with a situation where we're heading for this tripwire. How do we get around it? And my suggestion, and I'll go over this quickly, is that we simply, the next step in the management of this river is to recognize that both the 48 and 22 compacts were written for a river that no longer exists. In the 90s, we recognized that California could no longer, use 5.2 million acre feet a year. So we had a 4-4 plan. In the mid-2000s, we recognized we needed clear shortage criteria guidance for the Secretary's decisions under the decree in Arizona v. California, and we got there. In the mid-2010s, we realized that Mexico had to be a part of the solution. We got there. Just last year, the lower division states said, we have a structural deficit, we own it. We got, so we're there. So what's the next conceptual framework and conceptual step? And that's the thing to realize, that some of these compact issues that are out there, we either need to agree to, in the interim guidelines, to ignore them during the period of the interim guidelines. I'm not a big fan of that idea, because what happens when the next interim guidelines expire? Things could be worse. So it's just recognized that these ambiguities in the compact exist, and we need to work around them. Now, one of my great frustrations is that I'll be candid, hearing the upper division states say, well, the lower basin is overusing its compact entitlement. We heard that a couple times yesterday. You hear that, every day from some folks, at least in Colorado. And that's a wonderful statement from a PR perspective, but ignores a simple reality. And that's that the 22 compact does not have a definition of beneficial consumptive use. John and I have been hammering on this. And it doesn't have a method for measuring compact apportionments. And the upper basin compact does. I brought a little, this is a 1948 upper basin compact report by Clifford Stone, who was Colorado's commissioner. It explains the upper basin compact in great detail. But one of the things they did in the upper basin compact is they took ownership of this issue that the 22 compact didn't have a definition or a way to measure compacts. And they wrote, and the purpose of Article 6 is to establish a method of measuring consumptive use of water. There is no purpose in making an apportionment of consumptive use unless a procedure for measurement is defined. We've heard others say, I think it's Peter Drucker, say you can't manage what you can't measure. And we have a situation in the basin right now where there is no standard. Arizona v. California, the decree says to do it one way. Upper basin, Article 6 says you do it another. And I guess today the information is being put on the website about the lower basin tributary uses. That's a whole nother world that I don't think anybody understands. So we don't have a common definition of what we're using under the compact. And for the upper division state officials to say the lower basin is using more than their compact, that's fine from a PR perspective, but there's no basis for making that statement, especially when you use their own methodology that was put in the upper basin compact, which is called stream depletion, which, believe it or not, is stream depletion theory suggests that the upper basin's depletion should be measured as the impact, and they use the word virgin, to the virgin flow of all upstream uses at Lee Ferry. And for the lower basin, it was at their 8.5 million acre feet was to be measured as the impact of all the uses in the lower basin on the natural flow of the river at the international boundary. And it's very clear from their testimony, they said that. So what I'm basically suggesting here is the next step is not call the basin compacts a foundation. Yeah, they're a foundation, but they've got some flaws. And to recognize they were written for a river that doesn't exist, and to move forward with solutions based on the river we have today, not the one we wished we had today, or the one we thought we had 40 years or 50 or even 100 years ago. Because there are some real downsides to doing that. But at the same time, I'm an optimist. I'm an optimist that in recognizing these basic issues, we will come up with a solution that makes sense for all. And my concern is we got to start telling people, especially our constituents, that there are some flaws here, and if we don't address those flaws, we're headed for another Arizona v. California, the 63 decision, which made matters worse on the river, not really better, at least in my view. So with that, I'll sit down and give us 20 minutes for some discussion.
All right. Yeah, you guys collectively covered a lot of ground, but we have more like 18 minutes for Q&A. Selena, is there any yes/no questions that we could go to?
This crowd does not ask yes/no questions. Well, there are a series of questions that I see as related, and so I'm going to set forth actually a series of my own questions to help us get them all to them. So I'll start by reading a few questions that are in here, and then I'm going to ask a few of you to explain a few things to help us get to the answer. So there's a question about, are there discussions about renegotiating the compact to adjust allocations and include tribes? What's the status of the effort? There's a question about Congress updating the compact to include tribes. And there's a question about whether the compact itself violates Jason's interpretation of the trust responsibility. So thinking that there's a lot of votes on all those questions, I'm going to ask you three to help walk us through the answer. And in particular, if we could start out with a couple of things. Who renegotiates or updates the compact, and what is the role of Congress? I think that would be helpful. And then if someone could talk about what the compact or compacts actually say about tribal water, I think that'll help us get to those answers. If you have to phone a friend, I have the Upper Basin and the 1922 compact open if you need the language.
I guess I've been nominated to take an initial stab. So I really like the fact that people are asking the tough questions, and I want to take them seriously by approaching them in bite-sized chunks. So the first piece is, what are compacts and what is the role of Congress in regards to compact formation? Is that a correct recitation of it?
Not only formation, but what would Congress's role be today?
Yeah.
And you can expand it to like law of the river, but the question was specific to compacts.
Yeah, sure. So a couple things, one of which I hope Eric will get a kick out of, the second one. But there are 3 ways under the US Constitution that states can address their relationships over interstate rivers. Equitable apportionment in the US Supreme Court, interstate water compacts under the Compact Clause in Article 1, Section 10 of the Constitution, or statutory apportionment. Those are the 3 pathways under our rule of law that are viable for addressing interstate relations over rivers like the Colorado. Congress has a hand in 2 of them. So I won't go into the compact clause's text, but I'll say Congress generally authorizes negotiation of compacts, and Congress has to ratify compacts if, when the basin state, federal, and maybe in the future tribal representatives get together and iron out a tentative deal. Whatever that deal that tentatively looks good at the negotiating table, whatever it might be, that has to go back to DC and get congressional ratification in order to take effect as law. So Congress has a hand in compact formation in that way. With respect to statutory apportionment, the 3rd pathway under the US Constitution, that's all Congress. That's negotiated through the congressional delegations, bicameral, both houses of Congress, right, and signed by the president. Yeah, so that's the first part. The second part, yeah. I haven't said this publicly, and I haven't heard anybody say this publicly, but I want to because I think it's fascinating. All right, for those of you who are familiar with the drought contingency plans, they were adopted by Congress. They were enacted by Congress, right? They were adopted in 2019 as a measure to bolster what had been accomplished under the 2007 interim guidelines. That's significant. If the 2026 management rules that are negotiated through this NEPA process, right? If they eventually are contained in a document that is enacted by Congress, the fact that Congress is enacting that document will cause the document to be a statutory apportionment for the Colorado River system for the period during which that document's in effect. Now, if you follow me, you follow me, and if you don't, I'll try again. Congress can enact laws that supersede prior laws, right? Compacts are, as the US Supreme Court has described, interstate contracts, but also statutes. If you have Congress enact the ultimate document that comes out of this post-2026 negotiation process, if Congress enacts that, that will have the force of statutory law for the duration during which the document is in effect. You will have an interim statutory apportionment for the Colorado River system. And that connects in interesting ways to the ambiguities that Eric alluded to. I'll shut up now.
Just one of the other questions is how does the compact deal with the tribes? We all know Article 7 talks about nothing in this compact shall be construed as affecting the United States obligations to Indian tribes. Well, my view is that was largely meaningless for protecting tribes because the United States obligations to tribes had to be approved by Congress. They involve money. So Congress had to appropriate them. They involve approving water settlements. So the United States obligations to tribes, it is what it is. But the other one that I think is more important, and this didn't really surface until the 40s, was that tribal rights are protected under Article 8 of the Compact, which states that present perfected rights are not to be impaired by the compact. And I think that is very clear I'm looking to the lawyers, but that's very clear in the in Arizona v. California and other decisions that tribal rights are pre-compact rights. So I'll give you an example. The Navajo settlement that we're talking about allows the Navajos to deliver water anywhere on their reservation. Their reservation is split really down the middle between Upper Basin and Lower Basin. They had nothing to do with that. That was never even discussed during the compact negotiations. And before the compact was written, I think they had an absolute right to deliver water as a tribe, as a sovereign tribe, to deliver water anywhere on their reservation. So the question is going to be, what's going to be the response of states to this provision are they going to try to use the compact to argue that you cannot deliver Upper Basin water to the Navajos, who cannot deliver Upper Basin water to Lower Basin parts of their reservation, even though the rights that they are operating on predate the compact by 60 years. So that'll be an interesting test for, I think, where we're going forward in this. Yeah.
So now I think we're set up to have you guys actually answer the questions, which were about whether we, Congress, should update, renegotiate the compact to better include tribes, and whether we think the compact violated Jason's interpretation of the trust responsibility.
Sure. We're negotiating up here.
You start. Let's start with the second part.
Oh my goodness. John's making me do the second part first, the injustice. I thought Doug's handsome John question or comment was an injustice. This is karma. All right. Yeah, breach of trust analysis is convoluted as hell. The U.S. Supreme Court has cooked it up since 1980, like I said, in the Mitchell 1 line of cases. And boy, we could do a full seminar on what that analysis looks like. If the question is whether Article 8 of the Compact, which says the United States will not impair the obligations of the United States to tribes, whether that could serve as the basis for a breach of trust action, I would like to think so, but as a betting man, I would say I don't think that would fly, especially with the current court's composition, the super majority of conservative justices on the court.
I guess I'll take a stab at the first one, but sitting in between these two is pretty intimidating with their level of knowledge. I guess I won't answer that first part because, again, I think the process should be set up to answer that question, and whether or not the compact is officially renegotiated to include tribes, that's something that should be determined by the tribes and the states and the feds through a probably formal process to figure out what that looks like. And so, yeah, I'm not going to sit up here and say the compact should be renegotiated for that reason, but I think we should have a space for a conversation to make sure that if that's the direction that the tribes want to go, that the states want to go, that the feds want to go, that should be in place. And so a bit of a punt, but that's how I feel about that.
Yeah, and keep in mind, I was not suggesting that there's an ongoing process of renegotiating the compact. I'm simply stating that in these negotiations, we should recognize the ambiguities and the uncertainties and start with recognizing those flaws because you cannot, in my view, successfully negotiate an agreement without acknowledging the flaws, without acknowledging the sickness, the underlying disease. So you got to deal with that. And I'm of the Jason view, when whatever this is done, they take it to Congress, and Congress will bless it. And I think just like we did with the Navajo settlement in New Mexico, and the 6,400 acre feet or whatever it is, that tiny amount of water that went from the Navajo Gallup project into the lower basin, we'll have a workaround, congressional workaround to do it. But acknowledging those flaws first will help us define what needs to be done in that congressional workaround.
I guess the only thing I'll just briefly add is, I mean, the last 100 years has shown this, the law of the river and the compact is whatever the states say it is. And so if we are expanding who's involved and what that say is, then that's what the law of the river is. And so I think that's why I say the process is important, because it is what we agree to as a basin. That it's not like we're not interpreting necessarily a legal document, but we have the flexibility to say what it is. And so I think if we have a more inclusive process, we can get to a better place with tribes and other sovereigns and stakeholders in general.
Well, thank you, and thank you for indulging my pre-questions. Let's move to a process question. Can we move beyond closed-door decision-making with the feds and 7 state reps? Colorado River C-SPAN, all residents in the basin deserve transparency over water.
Yeah, I like the idea of C-SPAN for the Colorado River negotiations. I mean, that sounds wonderful.
I think that would actually help my daughter sleep at night. I guess I'll take a stab at that. I mean, this is the fundamental challenge with Colorado River negotiations is pretty much universally we agree they need to be more transparent, more inclusive, include a broader viewpoint, perspectives. But then you'll also hear primarily from the basin states that we as sovereigns have to make decisions. And sometimes those decisions and those negotiations need to be private and behind the scenes. Otherwise, we would never come to an agreement. And if we don't have these behind the scenes conversations, we can't offer up solutions that maybe would get us killed back home if that's a public process. So, and I'm not saying that's right, but that's what the basin states would acknowledge is we need some level of ability to negotiate without the public eye. And I think there has to be a balance. And I think the pendulum has been far too long in behind the scenes, closed door, we don't know what's happening. And just look more recently, the DCPs, for example, that was a pretty behind the scenes process. We didn't get a lot of transparency around that. Even more recently, some of the post-2026 guidelines, I've heard from folks saying that was also, has been to this point, kind of behind the scenes. We haven't had a clear viewpoint into what the states are thinking. But you look back, 07 guidelines, even the basin study, a little more inclusive, a little more open, a little more transparent. And so I think the pendulum is shifting, it needs to move, and we need to strike that balance. And I don't want to seem like I'm arguing that the states can just go off and do their own thing, although I understand the argument for why that's needed. But we do need that level of transparency. We do need a balance. And it's a challenge to find that balance, but it's important to find that balance.
May I? All right. I'll start off just with a basic proposition. Who decides determine what gets decided. Who decides and how determines what gets decided, right? It's incredibly important to think about the structure of decision-making processes. What I have to say has less to do about transparency than the formalization of a structure. And I'll be specific and hopefully practical in my 2 cents. I think it's remarkable that the Upper Basin Compact, when it was cooked up in 1948 in Vernal, right? Eric's written all about the history. They chose to establish an interstate administrative agency for the compact, the UCRC. I think it's remarkable that in the history of the UCRC, just a couple months ago, earlier this very year, they were willing to form an MOU with tribes recognizing tribal sovereignty and formal relationship building, formalizing relationship building with the Upper Basin tribal sovereigns. Those are powerful steps. In contrast, the 1922 Compact, during the negotiations, the subject of establishing a basin-wide commission was broached. It was talked about. John's written about this. And the answer, based on their views of federalism at that time, was no. No go. We're not doing this. Again, fast forward a half century, 1948, it was done with the UCRC. And fast forward another, someone help me with the math, 75 years, we now have a commission with an MOU with Upper Basin tribal sovereigns. That's the trajectory. That's the direction I believe water governance needs to go in this, along America's Nile.
I'm going to sneak in one more question. We have 3 minutes. This is for you, Eric. Some Upper Basin folks say climate change is depleting the river, so the compact delivery obligation no longer applies. What's your take?
Well, it's the sparing with the language in the compact, you know, the upper, there are, in my view, there are non-depleters and there are deliverers. And I didn't have time to go into that, but the previous generation, well, at least Clifford Stone's generation, they didn't talk about, they focused on their delivery obligations. Today we focus on our non-depletion obligations, but it's something that we kind of constructed, I think, a few years ago, well, or maybe a couple decades ago. I think it's an enormous, really important issue and a really big flaw in the system, which is, yes, the compact requires the Upper Basin states to not cause the depletion of the flow below 75 million acre feet. Well, we're using 4.5, whatever the new number is now that it's posted on the website. And it was never envisioned by any of those who negotiated these agreements or even the laws that passed that, 30 years later, we would have 12.5 million acre feet on the river. So we've got to, when I say the river no longer exists, we've allocated 17.5 million acre feet of consumptive use on a river that's about 13 million acre feet. Okay, so something's doesn't work. And I understand the Upper Basin's argument, but at the same time, if I'm not a court person, but if that argument were to prevail, like at a court level, aren't we reopening every compact in the Western United States? If we're going to reform the Colorado River Compact because the Upper Basin can't make its commitments because of climate change, what does that mean for, 25 other compacts? It's a big step.
Yeah. All right. Celine, that was really well done. Yeah. Thank you.